dear faculty and students, welcome to our first Moot Court and Mediation event, a role-playing activity of dentist to customer-patient malpractice performed by volunteer students from both dentistry and law schools. This joint educational activity is explored as an alternative learning method, but also as an opportunity for interprofessional education among our two EUC schools. And now I would like to ask the Vice Rector to come and address the audience.
Good afternoon, everyone. Nice to see you all here. I won't disturb you with a lot of talking. I just like to say that I'm very happy to attend this event today. This has been an initiative of your instructors and the colleagues involved in this activity. The initial idea, the initial prompt for bringing together colleagues from the School of Dentistry and the School of Law that eventually evolved in this Moot Court that you will have today. Started a year ago when colleagues appearing here today, Professor Kavadias and Dr. Haralambos Tamelos and Dr. Konstantina Taufik participated in an initiative of my office, of the Office of the Vice Rector of Academic Affairs, on establishing, as part of the ongoing professional development of our faculty here at European University Cyprus, the first faculty professional learning communities. So our colleagues from various schools set up a learning community to address issues of their own concern. And out of this community, the idea of bringing together issues relating to the School of Law and the School of Dentistry came up. And this is an outcome of this process, or at least is an outcome of that initial one-year plan that we had last year. I'm very happy to see that that idea evolved in what we see today, and I would like to congratulate the four colleagues involved here, not only Professor Kavadia and Dr. Stamelos and Dr. Taufik, who participated in last year's initiative, but also Dr. Athina Moraiti, who merged also her support to this group, and we have today this lovely event. It's not usual to have activities linking so different and distinct disciplines, the law and the dentistry. So looking forward to see the outcome of what you have prepared. And I'm sure for all you students that participated in this process, apart from congratulating you in participating in this process, this will be a great learning adventure. Thank you very much.
Thank you very much, Mr. Vice Rector. And now I would like to ask the Dean of the School of Dentistry to come and address the audience.
Dear Vice Rector, dear faculty, dear Law and Dentistry Schools, ladies and gentlemen, I would like to congratulate Lecturer Stamelos, Professor Kavadia, Lecturer Taufik, and Dr. Moraiti, as well as students and faculty involved in the initiative of the Moot Court and simulation of mediation in dental practice. Nowadays, the successful practice of dentistry should not be characterized only by success, efficiency, and safety of the dental procedures performed to the patients. It must be associated with strict implementation of the rules and legislation in effect for the practice of dentistry and for function of the dental clinics in the respective country or region. During the last decades, the practice of dentistry is characterized by the formation of a newly introduced entity, which has evolved to encompass the width and complexity of a scientific discipline, namely litigation and malpractice. The unlikely blend of principles derived from the broader health and law science is man-made. It cannot be defined by natural rules, and its implications vary greatly even among the places where it exists. In addition to the theoretical knowledge and the practical skills required for maintaining clinical competence, dental practitioners should be familiar with existing generic and specific legislation that exists in the country or region where they plan to practice dentistry. For example, in the United Kingdom, all general dental practitioners or specialists in practice are required by law to justify every radiograph that they take or prescribe. If the radiograph has no utility for diagnostic or treatment purposes, it is considered as unnecessary, and the referring practitioner is legally liable for malpractice and lawsuit. In most of other countries, however, this law does not exist. Although the risk of litigation due to medical and dental malpractice is much higher in some parts of the world, medico-legal involvement and risk management do concern health services providers almost everywhere. In some countries, like USA, Canada, UK, we have the phenomenon that doctors study law or lawyers study medicine and dentistry for being professionally eligible to represent malpractice cases in the courts of law. Today, practitioners in many parts of the world devote a significant amount of time, effort, and money to avoid legal entrapment arising from undesirable outcomes of medical and dental procedures, which resulted in a harmful outcome for the patient's well-being. The desire for legal protection of the practitioner has led to the prescription of extra diagnostic procedures to comprehensively describe the pre-treatment health status of the patient, to the increase of malpractice coverage insurance premiums, and the application of complicated legalistic informed consent protocols. In dentistry, where the risk of harm is considerably less compared to other more invasive medical acts, malpractice has taken on significant dimensions in the past decade, thus stimulating the scientific community, dental organizations, and educational institutions to present guidelines for avoiding the unfortunate outcomes. Having all this in mind, I think that today's event is an exceptional educational opportunity for our dental students, which will contribute in realizing that practicing lege artis, that means in accordance with the approved rules of the profession, as opposed to novel or improvised methods, is the safest way to minimize litigation and malpractice. However, since in all medical and dental procedures, complications and adverse events may occur, a good medical and dental history, a systematic and comprehensive collection and elaboration of diagnostic data, as well as an adequate patient's informed consent must constitute the minimum requirements to protect the clinician. Thank you very much.
Thank you, Dean. With this activity, our students are exposed not only to the dental legal considerations and how to act in a courtroom, but also they develop their critical thinking and problem-solving skills from multiple angles, far beyond than when following the standard curriculum methodologies. Furthermore, our students are educated in collaborating as professionals in a team, such an important skill for their future careers. Although this activity today involves dental malpractice, we need to state that the EUC dentistry students are trained to practice excellence in dentistry so as to minimize such incidents in their careers. The first case today shall be resolved through a moot court trial. This is a true story case that was retrieved from the law and dental databases and was adjusted to an academic framework. The actual expert witness in this court case has been our dean, Professor Athanasiou, and we do thank him for his contribution in preparing this project. this case has been also published. And if you scan this QR code, you can download the original publication for this case. We do hope you enjoy the event as much as we did when preparing for this activity for the last 6 months. Our students have worked enthusiastically and put a lot of hard work into that. And now the court starts.
Good afternoon, and thank you for joining us. This case pertains to a 12-year-old girl, the patient plaintiff, who, following orthodontic therapy with removable devices administered by a general dentist, the defendant, exhibited gingival inflammation and mobility of the upper anterior teeth. The diastema resulting from the treatment was addressed using an elastic band. Despite the prescription of analgesics, the patient continued to experience persistent discomfort, pain, and tooth mobility in the upper anterior region. Seeking further intervention, the patient consulted an orthodontist who stabilized the teeth and referred her to a periodontist for scaling and root planing. Unfortunately, the symptoms persisted, and 2 fistulae developed between teeth 11 and 21. To address this, an endodontist performed a root canal treatment, resulting in the reduction and eventual complete eradication of the fistulae and substantial healing of the apical bone. However, tooth mobility remained unchanged. Subsequently, the patient sought the advice of a second orthodontist who referred her to an oral surgeon approximately a year after the onset of symptoms. During surgery, 2 elastic rubber bands were discovered near the apex of the teeth and were promptly removed. Following the procedure, orthodontic treatment was initiated. A follow-up examination 2 years later revealed a healthy periodontium and no observable tooth mobility. In light of these developments, the family, both parents and the child, is pursuing as 3 plaintiffs legal action against the initial dentist, the defendant, for malpractice, invoking Article 914 of the Civil Code pertaining to cases of wrongdoing.
The hearing starts. Docket number 1. The first case is the case of Sophia Jackson versus John Clark. Is Miss Jackson here? Miss Jackson? Not present. Is Mr. Clark here? Not present. This case is cancelled. Now we turn into case 2.
The second case is the case of Maria Vasiou, Eleni Vasiou Kalatha, and Vasilis Vasios versus dentist Jennifer Brown. Is Miss Vasiou here?
No, she's not present.
Is Miss Vasiou Maria here?
No, she's not present.
Is Mr. Vasios Vasilis here?
Yes, he's present and he is represented by me, Dimitris Papadimitriou.
So, Vasiou Maria is not here, but she is represented by the attorney Dimitris Papadimitriou. Vasiou Kalatha Eleni is not here, but she is also represented by the attorney Dimitris Papadimitriou. And Vasios Vasilis is here, and he is represented by the attorney Dimitris Papadimitriou. Is Miss Brown here?
Yes, she's here, and she's represented by me, Konstantinos Fotinos.
So, Miss Brown is present and represented by Konstantinos Fotinos. Do you have any witnesses or any expert witnesses?
Yes, we do.
We also have.
Very well. Please approach the bench and produce us the relevant documents.
Your Honor, esteemed members of the court, I am Dimitris Papadimitriou, representing the plaintiffs in this case. Additionally, my client, the father plaintiff, requests to be heard during the procedure, given the sensitive nature of this case. Do you agree?
We also have the same request.
We will deliberate for a moment. We decided that due to the difficult nature of this case, both parties will be heard.
Now, we go on with the opening statement of the attorney of the plaintiff, Mr. Dimitris Papadimitriou.
Your
You may
Honor.
start.
Thank you. Your Honor, esteemed members of the court, my client, a young girl who has suffered due to the wrongdoing of a negligent dentist who committed a dental malpractice, and this caused emotional distress to the parents, who also paid off a lot of expenses due to this malpractice. Unfortunately, the mother and the child are not present today due to emotional distress. Allow me to present the facts of this case. The young girl required dental services and treatment commenced in 2020. After 2 years, elastics were placed according to the dentist's instructions. However, the elastics disappeared, leading to intense pain for the girl plaintiff. The parents' plaintiffs promptly contracted the dentist defendant, who attempted to reassure them that everything was going according to a plan. Despite an examination, the pain persisted, and the dentist prescribed analgesics. Regrettably, the pain continued to worsen, and the girl's teeth became mobile. Seeking a second opinion, my client, the parents' plaintiff, consulted a pediatric dentist who diagnosed her with mobility and recession of teeth 11 and 21.
Kindly, could you be more specific about that?
Of course, teeth 11 and 21 are the upper incisors.
Okay, thank you.
This marked the beginning of a 2-year chain of painful events, during which the girl plaintiff visited various doctors, including dentists, maxillofacial specialists, 2 orthodontists, a periodontist, and an endodontist. The second orthodontist identified the elastics as the cause of the problem and referred the girl to a maxillofacial surgeon. The surgeon informed the parents that the lost elastics had caused bone resorption, leading to the pain. Subsequent treatments included severe inflammation of the gums, tooth extraction, tooth implant surgery, and the creation of dental splints. The girl plaintiff faced dietary restrictions, required supplements, and experienced emotional distress that continues up to this day, due to this day affecting her school and social obligations. So, we seek for the damages and emotional distress reparation. Thank you.
Thank you. Councillor Mr. Fotinos, please proceed with your opening statement for the defendant.
Your Honor, esteemed members of the court, I, Konstantinos Fotinos, the dentist defendant's lawyer, after a thorough observation and study of the facts of the case, state that there was no dental malpractice on the part of my client, Ms. Brown. The dentist defendant faced a severe case of dental anomaly and, with the agreement of the parents, undertook a 2-year treatment from 2020 to 2021. During this period, elastic bands were placed to address the gap between the teeth. Despite the patient plaintiff experiencing pain after the dental procedures, the dentist defendant, after a careful examination that revealed no oral cavity problems, prescribed analgesics to alleviate the pain. My client, dentist defendant, is not liable under Article 914 of the Civil Code, which defines the concept of mens rea in the event of a wrongdoing, as she was in error since she was not fully aware of all the facts. The parents concealed from the dentist defendant that one elastic band had been lost, information crucial for understanding the case. According to the expert opinion, Ms. Thalia Black, the dentist defendant could not have discovered this information without the parents informing her, nor it could be discerned through an X-ray, as elastic bands are radio-transparent. The patient's plaintiff's treatment was discontinued in 2021 by my client, dentist defendant, and continued by other colleagues. This creates a large gap in the flow of treatment and leaves room for dental errors by fellow dentists. The involvement of multiple dentists in this case complicates the identification of the cause of the patient's plaintiff's illness, as noted by expert Ms. Thalia Black. In conclusion, my client, dentist defendant, adhered to all generally accepted and applicable rules of dental science. The responsibility for this patient plaintiff was transferred to her colleagues, creating uncertainty in establishing the causation of mens rea. The expert witness, Ms. Thalia Black, affirms the excellent work of my client defendant and is certain that there was no dental malpractice, emphasizing my client's dentist defendant's excellent work and contribution to improving the oral health of the 12-year-old. Since visits to my client's dentist defendant's office were interrupted, her relevance to the case was also discontinued, as she had no control or information from her colleagues about the patient's plaintiff's treatment. My client, dentist defendant, would only be responsible if she was the sole attending dentist, which is not the case, as the patient's plaintiff's parents decided unexpectedly to change doctors and treatment approaches.
Thank you.
Thank you.
Witness for the plaintiff, Mr. Ioannis Harzano, please approach the bench. Witnesses and expert witnesses for the plaintiff and the defendant, please leave the room. Will you take an oath?
Yes, I will.
A religious oath?
Yes.
A
Yes.
Christian religious oath?
Yes.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth,
I swear to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Please proceed.
My name is Ioannis Harizanu, and I am the witness of the plaintiff. I am a family friend of the 12-year-old patient from the father's side. With the patient's father, we have been friends for years, as a result to know in detail the suffering that my friend's daughter suffered all this time. As far as I know, the young girl, like many children of her age, consulted an orthodontist with her family in order to correct a gap she had in her two front teeth. The particular dentist used an outdated method.
Objection, Your Honor. No opinions allowed.
Objection sustained. Mr. Harzan, please, you testify only the facts. You have no right to comment on the facts.
The particular dentist used a method to repair the gap in her teeth, and in addition, as it appeared, the dentist did not know how to apply the treatment correctly.
Objection, Your Honor.
Objection sustained. Please, no comments, only the facts.
The parents saw their child suffering daily from severe toothaches without being able to help her. I typically remember the little girl not being able to go to school for several days because of the pain which affected her negatively since she had fallen behind in her schoolwork. Also, because of the dentist, the family had to visit many doctors to get further opinions in order to find a solution to this problem. The girl's parents spent a lot of money to be able to fix the particular problem that arose. The 12-year-old girl, at such a young age, was forced to constantly visit doctors and undergo surgery to finally treat the problem. As you can imagine, the orthodontic treatment that was carried out proved wrongdoing for both the young girl and her parents. In my opinion...
Objection, Your Honor. No opinions allowed.
Objection sustained. Only expert witness may express their opinion. Witness shall remain only on the facts.
The original dentist caused physical harm to the young girl because of the fact she applied treatment with insufficient knowledge of its subject. Thank you.
Thank you. You are now excused.
Witness for the defendant, Ms. Sofia Zagotti. Please approach the bench. Will you take an oath?
Yes, I will.
A religious oath?
Yes.
A Christian religious oath?
Yes.
Put your right hand on the Holy Bible and repeat after me. I swear to tell the truth,
I swear to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Please proceed.
My name is Sofia Zagotti, and I have been a patient of the dentist defendant for approximately 4 years. I began seeking their services after my previous dentist retired. Throughout my tenure as their patient, I have undergone a variety of dental procedures, most of which were routine. In addition to my annual checkups and plaque and tartar cleanings, I have had fillings in 4 teeth, received teeth whitening treatments, and undergone the removal of my wisdom teeth. I have consistently experienced the highest level of professionalism and care at Dentist Defendant's Clinic. The treatment plans were explained to me comprehensively, providing a clear understanding of what to expect. This transparency significantly alleviated any anxiety I may have had. Throughout and after each procedure, I experienced minimal to no pain or discomfort. This was particularly notable during the removal of my wisdom teeth, as I exhibited only minimal swelling and pain in the days following the surgery, both of which swiftly disappeared. This allowed me to resume all my normal activities, including work, without disruption. I am aware that typically such a procedure involves a challenging and painful recovery, especially in the initial days, and I am extremely grateful to have avoided such difficulties. In conclusion, the dentist defendant has consistently delivered excellent medical care over the past 4 years. I have always found them to be professional and meticulous in their approach to dentistry. Thank you.
Thank you. You are now excused.
Expert witness for the plaintiff, Ms. Rachel McAdams. Please approach the bench. Will you take an oath?
Yes, I will.
A religious oath?
Yes.
A Christian religious oath?
Yes.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth,
I swear to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Please proceed.
I, Dr. McAdams, am fit to be the expert witness for the plaintiff since I have been practicing excellency in orthodontics for 20 years. I studied thoroughly the evidence submitted to the court and I produced the following report. After following a 12-month orthodontic treatment, combining a removable appliance with an elastic band in the upper anteriors to close the diastema, the defendant was informed by the parent of the plaintiff that the patient was experiencing intense pain in the upper anteriors. As you can see on the screen, this is a type odont with an elastic band placed, simulating the treatment provided by the dentist. The defendant examined the plaintiff, prescribed analgesics, and reassured the plaintiff that this was not a case to be of concern. The plaintiff, however, suffered from severe periodontal destruction around the upper anteriors and severe tooth mobility that was managed by several dentists and finally by the oral surgeon who discovered the submerged elastics. This is the clinical picture from the surgery provided by the oral surgeon, showing the elastic bands located at the apex of the teeth. Although the plaintiff or her family did not mention anything about the bands vanishing, it was a dentist's responsibility to suspect and ask, since this constitutes to the differential diagnosis of the case. At the time of the fact, similar published studies indicated that elastic bands placed directly to the teeth for closing the diastema between the upper anteriors is not an acceptable treatment. Elastics should rather have been anchored and attached to the teeth through the brackets or through any other fixed orthodontic appliance. In my expertise opinion, the dental malpractice of the defendant has led to the severe deterioration of the oral health of the plaintiff and the plaintiff's family to suffer from the economic burden. Furthermore, the masticatory function of the plaintiff has been compromised due to the mobility of the upper incisors, so chewing of solid foods has been impaired. Moreover, poor self-esteem due to compromised aesthetics has led the patient to stop smiling. Thank you.
Thank you. You are now excused.
Expert witness for the defendant, Ms. Talia Black. Please approach the bench. Will you take an oath?
Yes, I will.
A religious oath?
Yes.
A Christian religious oath?
Yes.
Please put your right hand on the Holy Bible and repeat after me. I swear to tell the truth,
I swear to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Please proceed.
I'm Thalia Black, dentist with 10 years of experience in practicing orthodontics. I've been appointed as an expert witness to defend the dentist in order to support the orthodontic treatment provided to the plaintiff that was initiated in May of 2020. In order to make this report, I have investigated thoroughly the dental records of the patient plaintiff that were provided to me by the defendant. Specifically, the defendant provided me with clinical photographs and an X-ray of the upper anteriors that were both taken during the time that the patient's symptoms started. What I could see on the clinical photographs was minor gingival inflammation around 11 and 21, consistent with minor gingivitis occurring during orthodontic treatment. Furthermore, in the X-rays taken at the time, neither signs of periodontal destruction nor any elastic bands were seen. Another difficulty for the management of this case by the defendant was that the defendant did not know how the case evolved over time, since the patient never returned for a follow-up visit to the defendant's office and never replied to defendant's phone calls. If the dentist had seen the patient clinically when the symptoms worsened, she might have thought about the possibility of the elastics being submerged, thus resolving the case earlier without so many complications and aggressive surgery. Regarding as to who practiced the malpractice, I'm not able to give a definitive opinion as to who is to blame for the bone destruction and mobility of the upper anteriors, since numerous colleagues were involved on the way. Thus, I believe that the other colleagues are also liable, since they did not suspect the case of elastic submersion, although there was extensive bone destruction and mobility. Finally, I clinically examined the patient after suing the dentist, and I have found healthy healing of tissues around 11 and 21, and no bending oral health issues. Thank you.
Thank you. You are now excused. The plaintiff, Mr. Vasios Vasilis, please approach the bench.
Your Honor, distinguished members of the court, I am Vasilios Vasios, appearing before you today to represent myself as plaintiff, and of course my daughter plaintiff and my wife plaintiff, and to share the distress we have endured over the past few years due to the medical negligence of the dentist defendant. With the little mental strength that remains, I stand here to implore the court to bring justice to my daughter plaintiff, whose life has veered off its intended path, marked by the medical malpractice of the dentist defendant. Throughout the treatment process, my daughter endured severe pain, a constant source of complaint. Initially, I attributed to the tightness associated with braces, drawing from my own experience wearing them during my middle school years. However, as days passed, her pain intensified significantly, impacting her daily life. She struggled to eat or sleep properly, spending much of her time at school, in the doctor's office, seeking pain relief, thus hindering her academic performance. Witnessing this dramatic shift in my daughter's life, I contacted the dentist defendant, who assured me over the phone that such pain was normal for a child wearing rubber bands, deeming them necessary for the treatment. Skeptical, I insisted on making an appointment, as I believe a proper medical opinion could not be given over the phone. Regrettably, during the appointment, the dentist failed to identify the source of the problem and insisted that my daughter's pain was entirely normal. Our gravest error was placing our trust in the dentist as a specialist, influenced by recommendations from acquaintances who deemed her an authority in her field. Consequently, we continued to entrust our daughter's plaintiff's health to her. Before long, the psychological pain escalated into the physical pain escalated into psychological issues. Our once smiling daughter transformed into an irritable girl, neglecting her school duties and withdrawing from her social environment. I deeply regret ever crossing the threshold of that dentist defendant's office. Instead of solution, all we received was a relentless psychological battle that persisted for 5 years. Thank you.
Thank you. You are now excused. The defendant, Ms. Brown, please approach the bench.
I treated the plaintiff for bilateral posterior crossbite correction with a removable appliance. The treatment resulted in upper anterior incisor diastema. I then decided to close the diastema using an elastic band encircling teeth 11 and 21, the upper incisors. This is a standardized technique used for closing diastemas. The patient came to my clinic as an emergency visit due to the pain and discomfort. Upon clinical examination, I found that the patient had lost the elastic band. Furthermore, at the time, no tooth mobility was detected. I thus placed a new elastic band. I also prescribed analgesics to address the discomfort that was attributed to orthodontic tooth movement. The patient was instructed to return for follow-up in a week. However, the patient did not keep the follow-up appointment and did not reply to my contact attempts. As I later got informed, she sought treatment visiting other colleagues that I had no idea about. Finally, I was very surprised to be notified that the patient had sued me. Thank you.
Thank you. You are now excused.
Now we go on with the final expert, Ms. Athena White. Please proceed. Will you take an oath?
Yes, I will.
A religious oath?
Yes.
A Christian religious oath?
Yes.
Put your right hand on the Holy Bible and repeat after me. I swear to tell the truth.
I swear to tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
You may start.
Taking into consideration the two previous expert opinions, expressing my opinion as an expert called by the court, I, Athena White, am a perfect fit as an expert considering my 15-year experience, not only as a practicing orthodontist, but also as an associate professor of orthodontics in European University Cyprus. This is a case of a 12-year-old female who presented with gingival inflammation and tooth mobility of the upper anterior teeth following orthodontic treatment with removable appliances by a dentist with some training in orthodontics to address dental crowding and eruption disturbances. The orthodontic treatment given by the implicated dentist using a rubber band for upper incisor diastema closure is an old practice of orthodontics that is no longer recommended in the 21st century. Furthermore, the treatment may have side effects of severe periodontal destruction if the elastics are dislodged in the gingival tissues, as have been published since 1976. Thus, the dentist ought to have known that using an elastic band to close a diastema can have this serious side effect. Looking into the scientific references in PubMed database, we retrieved 3 publications of similar cases with gingival submergence of elastics of the upper anteriors along with periodontal destruction. More specifically, and by scanning with your cell phones the QR codes on the screen, you will be redirected to the PDF files of each of the mentioned studies. Zimmerman and colleagues, in 1976, published 4 similar cases with intraoral elastic bands in upper anterior used for orthodontic purposes. Elastics had apically migrated, causing periodontal destruction, and surgical intervention was necessary. Finkbeiner and colleagues, in 1997, similarly reported a case that an elastic band was placed around his 11 and 21 to close the diastema in a 10-year-old boy. Within 3 weeks, severe mobility occurred for the upper incisors, deep periodontal pockets, and severe periodontal destruction occurred. In this case, however, treatment was initiated by the mother, a non-dentist. In 2011, Alcutube published a case of a 9-year-old girl that presented with pain and mobility of the upper incisor for the past 4 months and bleeding while brushing. An elastic band for the closure of the diastema, similar to our case, was used by a general dentist. Thus, the case of the defendant is a rare complication that had been previously presented in the literature in similarly treated cases. Elastic bands are not radiopaque, meaning they cannot be identified in an X-ray. However, the defendant, when she saw the elastics not to be present during the follow-up exam, should have suspected that this may have occurred, since it is clearly stated in the literature. Furthermore, if she had suspected it in the very early days of elastics being submerged, discovery and recovery of the elastics may have been easily possible without even performing a surgery. The dental malpractice is based on the fact that the dentist did not interpret the symptoms of pain and clinical findings of swelling of the gingiva and tooth mobility. Treatment by closing the diastema with an elastic band placed between the 2 incisors is a very old dental practice, not supported anymore by the current guidelines of orthodontic treatment, and has no place in the treatment options of the 21st century. The dentist, instead, should have anchored the elastic bands to the brackets and should have informed the patient about the possibility of losing the elastic band and the adverse consequences if it was submerged under the gingiva. Thus, if the defendant dentist had followed continuous professional development, as all dentists should, in order to practice according to the most updated guidelines of the profession, she would have been informed about the possible side effects of her management. Furthermore, the patient, that she was then a child only, had to undergo aggressive surgical interventions to have her teeth salvaged that affected her attitude and behavior towards dentistry, contributing to a tendency towards dental phobia. And of course, the prognosis of the teeth for the future remains uncertain. More dental treatment might be needed to sustain the teeth, affecting the quality of life of the patient and financially burdening the family. Thank you.
Thank you. You are now excused. Mr. Papadimitriou, please proceed to your closing statement for the plaintiff.
Your Honor, esteemed members of the court, in light of the things heard during the procedure, we hold that the dentist defendant is liable under Article 914 of the Civil Code regarding tort, as she did not act diligently and in accordance with the appropriate rules of dentistry. Pursuant to Article 929, addressing damage to the body or health, we request compensation for damages, including hospitalizations and additional expenses totaling 30,000 euros. Moreover, the plaintiffs request an additional amount of 10,000 euros to cover various costs incurred during the treatment period, included perio visits, taxi rides, dietary modifications, and X-rays. Additionally, we seek 30,000 euros, 10,000 euros for each plaintiff, to address emotional distress under Article 932 of the Civil Code, considering the traumatic experiences and procedures undergone by the underage girl. Furthermore, we in principle request the reimbursement of legal costs which we alternatively propose to offset due to the complexity of the legal issue at hand. Thank you for your attention.
Thank you.
Mr. Fotinos, please proceed to your closing statement for the defendant.
Your Honor, esteemed members of the court, there has been no wrongdoing and there is no mens rea of my client dentist defendant, and I clearly state that she is not liable for wrongdoing. According to today's hearing, it is established that my client is not liable for wrongdoing and no civil liability exists on the part of my client. Moreover, I request the reimbursement of the legal costs, which I alternately propose to offset due to the complexity of the legal issue at hand. Thank you.
Thank you. Now we want the public to vote. Tell us, by show of hands, how many of you think the dentist committed dental malpractice. So, how many of you think that Mr. Papadimitriou has right? You can also scan the following QR.
7, 8, 9, 10.
Just a minute, please. Now, please tell us, by show of hands, how many of you think the dentist did not commit dental malpractice. So, how many of you think that Mr. Fotinos has right?
Can we go back to the QR code? Nice.
So, you decided that the dentist did commit dental malpractice by votes 22.
Out of 2.
In reality, the court found the dentist is liable for dental malpractice and awarded 30,000 euros in damages to the plaintiffs, the girl and her parents. We would like to thank you all for being here today and for your participation to the procedure of the voting. We hope that in the future you will have the chance to experience something similar. Thank you very much.
Okay, so this is the end of this first part, the court trial, and we'd like to congratulate our students and give an intermission of 15 minutes, and then we continue with the second part, which is exciting as well, the mediation process. So we are all expecting you back for that.
Θα μας φάνε.
ξέρετε, στη διαμεσολάβηση. Θα φέρουμε λίγο εδώ. Πήγα λίγο. Αυτοί οι 5 εκεί σίγουρα θα πήγαν. Για τους άλλους δεν ξέρω.
να έτσι.
Όχι, έχουμε κάτσει όλοι.
Ή φτιάξτε το μου. Ή φτιάξτε το εσείς την ώρα που μιλάω.
So I welcome you to this second part. The second case today shall be resolved through mediation. The panel consists of 6 students from dentistry and 5 from law. The summary of the case: this is a case of a minor who received dental rehabilitation under general anesthesia, during which the dentist injected 2 carpules of local anesthetic, probably into the arterial circulation, rapidly and under pressure. This was implicated as the cause of severe vision loss for some days, giving rise to particles in the eyes and causing permanent vision loss. The original case has been adjusted to an academic framework. And now the mediation starts.
On October 22nd, 2020, Steve Orfanidis, a pediatric dentist, conducted multiple procedures on a 7-year-old boy named George Aguili under general anesthesia using supplementary local anesthetic. After the child woke up, he began complaining of discomfort near the right eye and reported vision loss that was never restored.
Subsequent examinations by an ophthalmologist revealed numerous particles in the choroid of the right eye, leading to allegations that these particles were transferred to the area due to improper local anesthesia technique. In an effort to seek resolution, the 2 parties, with the child represented by his mother, Katerina Geli, have been referred to mediation.
Good afternoon, and thank you for taking part in the mediation procedure. My name is Harula Gutu, and together with my colleague, we will be serving as your mediators. You may call me by my first name.
I would like to welcome you as well. My name is Maria Tsautu, and as Harula mentioned, we will be serving you as mediators today. You may address me as Maria. As you already know, this is a voluntary procedure, so I would like to thank you for your participation. Before we start, I would like to ask both parties to sign an affiliation agreement. This agreement entails that both parties participate in mediation on their own accord and that both parties and mediators' fee is set at €150 per hour. Please sign the agreement.
We would like to start by explaining the procedure so you'll understand what will happen next. We will begin by asking you, the parties, the attorneys, and the witnesses, to explain the situation from your point of view. After that, we will agree and identify the key points of disagreement. Then, we will work to reach a possible solution that both of you feel comfortable with, as this is our goal. Our role here is simple. We're not here to judge you, nor tell you if you're right or wrong. The importance of this procedure is finding a solution that both of you agree with, since you're going to be the ones living with the outcome. Something that I would like to emphasize is that this is a private procedure without prejudice, meaning that everything is going to be strictly confidential between us. You might notice us taking notes from time to time in order to keep track of what you're saying. However, this will not be used against you in the chance that we fail to reach an agreement. Our notes will be destroyed afterwards as to keep the confidential nature of the procedure.
Finally, we would like to discuss some ground rules. We kindly request that you refrain from interrupting the other party when they are speaking. Additionally, we ask that you avoid using abusive language, making insults, or name-calling, as this type of behavior can hinder the process for reaching an agreement. These rules are particularly important when you present your perspective during the discussion. Do you agree with these terms?
Yes.
Yes.
We will now begin by listening to your perspective on the situation. We would like to start with Mrs. Katerina Aguili, as she initiated the mediation. Following that, we will hear from Dr. Steve Orfanidis. Subsequently, we will listen to your attorneys and the witnesses, alternating between the two of you. Ms. Angeli, please begin and let us know how we should address you.
Hello, everyone. My name is Katerina Angeli, and I'm George's mother. You can call me Miss Angeli. On the 22nd of October 2020, Dr. Steve Orfanidis performed several dental procedures on our 7-year-old son under general anesthesia. After our son woke up from the anesthesia, there was some redness on his right side, but we thought it was normal since he had 2 teeth removed around that area. After returning home, his cheek began to swell, which worsened as time passed. We took him to the hospital later that evening to have him checked, and after the examination, we were sent home. We were told to wait a couple of days, since that most probably would resolve by itself. We were also advised to come back to the hospital in case his condition did not improve or in case it got worse. 3 days later, we returned to have him checked by an ophthalmologist, Dr. Solomou, and his condition kept getting worse. Dr. Solomou told us that the eye muscles were swollen and that our child had severe vision loss and that such complications are quite rare and might require several weeks to resolve. We went home and tried to reassure our son, who kept on asking about when he would be able to see again. A month later, he could still not see. So we went back, I'm sorry.
That's okay.
A month later, he could still not see, so Dr. Solomou ordered a special diagnostic exam and discovered a lot of small pieces inside his right eye. She told us that those pieces were responsible for our son's poor vision and that they came from the injection that Dr. Orfanidis performed to our child during the general anesthesia. After looking into what might have gone wrong, we learned that Dr. Orfanidis did not conduct a proper injection since he did not follow the rules for safe dental anesthesia, and he is the one to blame for our son's poor vision. Therefore, we decided to sue Dr. Orfanidis as we want justice and compensation for what our child and our family are going through. I had to stop working so I could assist my child, who since then needs tremendous help to complete his daily tasks. No one ever mentioned to us the risks of those dental procedures. At this point, we want to make certain that no family will ever have the same experience as us, namely, take their children for dental treatment and return home with permanent vision loss without even knowing about it as a possibility.
What would you do differently if you knew that this dental treatment could lead to vision loss?
We would not proceed with the dental treatment. Who would really if they knew that this could lead to permanent vision loss?
Why did you not seek dental treatment for your son earlier?
Well, when I first noticed some black spots and holes on his teeth at the age of 4, I referred to his pediatrician and consulted with him. But then he told me that these were his baby teeth and I shouldn't do anything about this unless they bothered him.
So why did you go to the dentist at that point?
Because he felt pain and he had difficulties in eating or even sleeping. So I started searching for a specialist to give us accurate information regarding my son's dental condition and the required treatment.
Why did you choose Dr. Orfanidis to provide your son's treatment?
I had 2 friends whose children had dental treatments performed by Dr. Orfanidis before, and they were very satisfied. Of course, if my child had not lost his vision permanently, I would also be satisfied with the treatment since I wouldn't be able to tell if it was performed correctly or not.
Thank you for your explanation. We would like Dr. Steve Orfanidis to now explain his point of view and how to address him.
Good afternoon. Please address me as Dr. Orfanidis. After examining George, his parents agreed to proceed with dental treatment under general anesthesia. as he had 8 teeth with extensive caries, carious lesions, basically to minimize any discomfort compared to if he was treated at a regular dental clinic, and to preserve as many teeth as possible. During the general anesthesia, I performed pulpotomies, meaning that I removed part of the nerve, and placed stainless steel crowns on 5 of the teeth and completed 3 extractions, 2 on the upper right side and 1 on the upper left side, as the teeth were unrestorable and the nerves were necrotic. Local anesthesia was performed in the upper and lower quadrants, with a total amount of anesthetic solution being approximately 2 cartridges, half a cartridge for each quadrant, which cannot be considered toxic in general for the weight of the child. All the teeth that were extracted had periapical lesions due to necrotic pulp, and the dental treatment in general would not have differed if it was performed in a general practice. Only more appointments and more extensive dental treatment would be required for at least some of the teeth. Topical anesthesia is a daily routine procedure, and I have a lot of experience without facing any complications like the one we had with George.
Is there a chance that you used more anesthetic solution than you should in the upper right area?
I used a very small amount, no more than half a cartridge with a 30-gauge needle. To perform the same treatment at a dental office, it would probably be needing 1 cartridge. So in general, there's no issue if I used more. In addition, George is slightly overweight, so I could have administered safely around up to 4 cartridges instead of 2, without any risk of overdose toxicity.
Why didn't you inform the parents that loss of vision could be one of the possible complications of their children's dental treatment?
In general, it's an extremely rare complication that I myself was never taught during either my undergraduate or my postgraduate studies. As even worldwide, there's less than 11 cases that have been seen with permanent ocular complications, most of which are from a different local anesthetic and usually on the lower side, and also performed by a different technique.
Would it be safer to provide dental treatment at a dental office instead of general anesthesia?
If the dental treatment was performed in a dental office, the local anesthesia procedure would be identical, but more anesthetic would be used during each appointment. And since George was not a cooperative patient, we would need to restrain or hold him, which also would increase the likelihood of injury or false aspiration.
Why did you advise proceeding with general anesthesia and did not give the option of no treatment?
No treatment is not an option. If heavily destroyed teeth are left untreated, heart and brain infections may occur, and they can even lead to death. For patients who do not wish to undergo treatment, I ask them to sign forms and mention the child's oral health condition and the risks of the teeth being left in the mouth. And if we don't report the parents for not seeking treatment, we are also to blame for dental neglect. Regarding the dental treatment under general anesthesia, it was the mother's decision, in general, because she did not want me to provide the treatment by restraining the child. And she was not comfortable even at the thought of having to use behavior management techniques to handle George's behavior. Maybe the behavior of George could have been confused by the parents towards not seeking the appropriate medical treatment needed.
Thank you, Dr. Arfanidis. Now, we would like to move to the attorneys. We will start with the attorney for Mrs. Ageli. Please introduce yourself and tell us how to address you.
Hello, my name is Maria Evangelia Kalaizaki, and I represent Katerina Angeli, the mother of George Angeli. You may refer to me as Ms. Kalaizaki. George Angeli, through his parents, referred to mediation with dentist Dr. Arfanidis, in which asked him to be awarded compensation, claiming that due to the administration of local anesthesia, without following the precaution measures, a few hours later had intense discomfort and swelling in his right eye, resulting in severe vision loss and no light perception. Angeli's family alleged lack of informed consent, medical negligence, res ipsa loquitur. After examining the situation, we can presume that Dr. Arfanidis engaged in medical malpractice that resulting in the blindness of the child's eye, which we will analyze. Firstly, the doctor didn't aspirate twice before each injection, and he didn't use the needle he had to while the patient was under general anesthesia, and as a result couldn't feel uncomfortable with the use of a bigger diameter needle. This needle of a greater gauge would have helped him make sure that in case he was injecting the anesthetic just into the blood circulation, positive aspiration would occur. Also, the dentist, as it was proven, used lidocaine instead of articaine, a more appropriate local anesthetic to use for dental procedure to children because of its better diffusion and cause of less side effects. Finally, the presence of a periapical lesion would also facilitate the spread of microbes and therefore of the infection to the surrounding tissues. The doctor should have treated the inflammation first before any dental procedure. He also injected the local anesthetic fast and under pressure, resulting in the known of all of us consequences to the child's health. Although the parents did everything possible to help their child, as soon as they understood the pain and suffering he has been brought to.
Ms. Kalaizaki, you stated that your client is seeking compensation from Dr. Orfanidis. Could you please explain how you and your client arrived at the conclusion that this is the best possible solution for your case?
According to Article 914 of the Civil Code, the obligation of compensation is borne by the person who will cause damage to another person in an illegal and culpable manner. Even though it is not explicitly stated, it is self-evident that the first condition is human behavior. The conduct in question needs to be external and illegal to be contrary to a prohibitive or mandatory rule of law. The guilt of the perpetrator has been determined as the third condition in a row to be able to use the 914 of the Civil Code. Another condition, which is directly related to the aforementioned, is that of imputability. It is necessary for the offender to understand the nature of his acts so they can be imputed to him. Civil Code 914 could not be applied, however, if the fulfillment of all the above conditions did not result in the occurrence of the damage. The last condition, which forms the connecting link of the above, is that of the causal link. In other words, the result of the damage needs to have been caused in natural course of things by the wrongful and culpable conduct of the tortfeasor. According to Article 57 Civil Code, anyone who is unlawfully insulted to his personality has the right to demand, among other things, compensation under the provision on torts, given that insult to personality also constitutes as a rule of law, since it is infringement of an absolute right, the right to personality. For all the above reason, and after analyzing Dr. Dimitriadou and Dr. Solomou's declarations, we believe that an obligation to compensate under Articles 914 and 57 of the Civil Code is established by Dr. Orfanidis to George Angeli and his family, due to medical malpractice which caused pain, swelling, and vision loss of the right eye of the child.
Thank you, Ms. Kalaizaki. Now we would like to address the attorney of Dr. Orfanidis. Please introduce yourself and let us know how we should address you.
My name is Elena Kalergi, and I represent Dr. Steve Orfanidis, the dentist who performed the procedures on the 7-year-old son of Miss Angeli. You may address me as Ms. Kalergi. On October 22, 2020, my client, Dr. Orfanidis, performed multiple dental procedures on the young patient. It should be mentioned that Dr. Orfanidis owns a dental clinic under the name of Children's Dental Care. Now moving on to my main argumentation. After the initial treatment and the appearance of the ocular symptoms, my client's patient sought medical care at a hospital where he was treated by a second doctor, specifically ophthalmologist Dr. Solomou. Hence, the treatment the patient received after the dental treatment by my client from other specialties of the medical field widens the possible spectrum of culprits. It could be considered collusion to only blame my client for the resulting situation after 2 doctors' work. According to Paracelsus's law, only the dose makes the poison. Upon interpreting and applying it to the situation at hand, we can see that local anesthesia can be toxic in quite high doses, specifically when the concentration of circulating local anesthesia becomes high enough. There can be unintended consequences such as visual and sensory disturbances, seizures, and muscle toxicity. However, According to a study called Etiology and Pathophysiological Pathways of Ocular Complications Associated with Local Dental Anesthesia and Odontogenic Infections, a systematic review by Yoshi et al. 2022, most ocular complications caused by the administration of a local anesthetic tend to resolve within a few hours. Permanent damage is only considered as an effect of local anesthesia and dental procedures in 11 recognized scientific sources, making it by far the minority opinion. Now, regarding the 30-millimeter gauge of the needle, an invocation of Dr. Dimitriadou's declaration of violation of standards of care would not be valid, since there is no protocol or policy that obligates dentists to use needles of a specific diameter when their patients are under general anesthesia. Furthermore, if my client were to choose a different anesthetic, like articaine instead of lidocaine, for example, which has a better degree of diffusion, that might have increased the chances of ocular complications. Additionally, the presence of pre-existing conditions that neither my client, Dr. Orfanidis, nor the patient's family were familiar with might have contributed to George's blindness. Therefore, my client made the best possible decisions with the facts that he was presented with.
Is there any indication in your and your client's opinion that could point to a different cause for George's condition, independent from the anesthetic?
Yes. The patient was evidently described as non-cooperative and therefore could have rubbed his eye, making the pre-existing eye condition even worse. Particles could have also pre-existed the dental procedures and the local anesthesia administration. The only way to find out the origin of the particles was to isolate them and analyze them, because they could have been present from other sources like vaccinations, dust in his eye, etc. That being said, since, as the ophthalmologist clarified, the particles were the main, if not the only, cause of vision loss, we can and will allege that Dr. Orfanidis, my client, was not liable for the damage to Mr. Angeli's eye. Therefore, the prerequisites of Article 914 of the Civil Code are not fulfilled, and any request for financial compensation should be deemed invalid.
Thank you for your explanation. Now, let's turn to the witnesses. Could the witness for Mrs. Angeli introduce himself and inform us of the preferred method of address?
Hello, my name is Stefanos Magiopoulos, and I am a friend and neighbor of the family of the 7-year-old boy who lost his vision due to a dental procedure performed by Dr. Orfanidis. You may refer to me as Mr. Magiopoulos. I was sitting on my balcony when I observed the Angeli family return home after their dental appointment, and both me and my wife felt that something was going wrong after we heard the child, George, constantly complaining about his vision. At first, we thought that those complaints were justified by the youth of the child. Half an hour later, I visited the Angeli family so I could return something that I have borrowed from George's father and make sure that everything was okay after the dental treatment he was so afraid of. But when I saw the child and his family, I realized that the situation was more serious than we had thought. The child was now complaining that he could barely see, and his mother was highly concerned. For this reason, they left in a rush. Later, I called the father of the child, and they informed me that they went to the hospital, and after further examination, they were informed that most of these complications might resolve on their own within days, and that if the child did not improve, they had to go back to the hospital. George's dad confided to me that he was so afraid that George's condition might not improve, but he could not say anything like that to his wife.
Did you communicate with the family again?
Yes, we had daily phone contacts. The condition of the child did not improve, so 3 days later they went back to the hospital where they were informed that it might take several weeks to improve. Katerina, George's mother, stopped working since George needed her assistance in everything, walking, getting dressed and eating, as it was very difficult for the child to keep his daily routine without being able to see from his right side. During the following month, where the anticipated improvement did not occur, I started thinking that George might suffer from permanent vision loss, and all of this might have happened due to a dental mistake.
What was your reaction after you learned that the treatment the child received could result in vision loss?
I was too stunned to speak at that point. I wasn't aware of the fact that a simple dental injection could lead to blindness. I was never informed about it by any dentist, and none of acquaintances have ever heard of that possibility. Both doctors from the hospital who examined the child and I believe that the visual complications arose directly from the dental procedures. I hope they can find a resolution that addresses George's needs and acknowledges the challenges faced by his family.
Thank you, Mr. Mayopoulos, for presenting your side of the story. Could the witness for Dr. Fanidis please take the floor and tell us how to address them?
I am Vasilis Vasios. You may call me by my first name. I have worked at Dr. Fanidis' dental practice for around 15 years as the secretary. During all those years, I have never seen a patient leaving unhappy. On the contrary, most of his patients told us how lucky they were to find a dentist like him. We had cases where the kids had their teeth extracted without even realizing it, and the parents were amazed about his attitude towards their kids, but also about the doctor's professionalism. Dr. Fanidis is one of the few dentists who devotes so much time explaining to parents what their kids have, which are the most appropriate dental treatments and how they will be conducted. That is why we always book 1-hour appointments for initial visits, although the clinical examination might only take 10 minutes. Also, Dr. Orfanidis is such a caring person. He is always available on the phone, at night, and on the weekends. He always makes certain that the children are happy when they leave the dental office, and he is extremely cautious with everything he is doing. He goes to congresses, he participates in seminars constantly, and he always uses the best quality materials that are released, regardless of their cost, as he wants to provide the best treatment for his patients.
Do you have kids?
Yes, I have 2 boys. One is 6 years old and the other one is 10 years old.
Now that you are aware of the incident, would you take your kids to Dr. Fanidis for dental treatment?
I have taken my kids to Dr. Fanidis for the dental treatment before. The eldest had an upper primary tooth extracted as the tooth became necrotic from the faulty direction of the eruption of a permanent tooth, causing an abscess. My child did not feel anything, and even though he was afraid at the beginning and not so cooperative, Dr. Orfanidis did the injection and the tooth removal without my child feeling anything. So for my son, he is the best dentist that exists, and he's the only one that he wants to go to. While regarding the incident that has happened, it does not change a bit my opinion about Dr. Orfanidis' skills and expertise, and I strongly believe that this complication is not the result of malpractice, but it's just merely a random incident, a complication that might happen to anyone without anyone specific to blame, since many factors might have contributed to the child's blindness.
So for you, Dr. Orfanidis could not be responsible for George's permanent vision loss. Can you explain which might be the other factors you talked about?
Firstly, from what I've heard, no one can say with 100% certainty that those small pieces in the eye, what those small pieces in the eye are, so maybe they are not related to the dental treatment. Secondly, if they resulted from the anesthetic solution, it does not mean that the dentist did something wrong, but maybe there was an anatomic issue there. My kid had severe destruction buccally due to the abscess. Maybe something like that could have played a role in George's case.
Thank you very much. We will move to the expert witnesses. Could the expert witness for Mrs. Aguili proceed with her point of view and tell us how to address her?
I am Mirto Solomou, and I have been a pediatric ophthalmologist for the last 20 years at Cyprus General Hospital. Please address me as Dr. Solomou. I am the one who examined the child 3 days after the dental anesthesia, as well as a month later. During my first examination, all extraocular muscles seemed to be swollen, and the patient suffered from vision loss. A month later, the child could still not see, and an optical coherence tomography was conducted, which revealed many particles in the choroid and retina of George's right eye, which were too many to count. These particles had to arrive by the arterial circulation from the dental injection, blocking the blood flow and thus causing an ischemic injury to the optic and oculomotor nerves. So for me, the dental injection was the cause of George's blindness, since no alternative explanations for the presence of these particles can be presumed.
Why did you see George 1 month after your initial visit?
Well, most ocular complications are resolved within a month. So the most appropriate time to conduct another examination was a month later. And of course, the parents were informed that if the condition got worse, they had to come back earlier.
How can you be certain that these particles are from the anesthetic solution?
I cannot. However, in my career, I have seen a lot of kids with leukemia who, after having solution injections in their cerebrospinal fluid, they have presented with particles in their choroids. And they were resulting from the preservatives in those solutions. I have seen tomography images like George's many times, and they were all associated with the preservatives in those injecting solutions.
If any of these kids suffered from permanent blindness, could you blame the doctor who treated him?
No, I would not, since in these cases it might happen. It is a common complication, and it's not because an injection was done without following precaution or safety measures. And please do not forget that this treatment is necessary for the survival of those patients, so it cannot be avoided. While permanent blindness after treating a baby tooth, it wouldn't be a risk that I would take.
Can you be 100% certain that these particles are resulting from the anesthetic solution?
No, since it is impossible to remove them and examine them without causing more harm, but from my experience, I am pretty certain about it.
Would you do something different if the particles in the choroid of the retina had been discovered earlier during the initial visit of George at the dental hospital, maybe prescribing a specific medication to treat the damage that might have been created?
Well, listen, up to date, several studies have been conducted that research retinal ischemia and its connection with permanent blindness, how to treat it, etc. An increasing number of treatments have been proven to interrupt the ischemic cascade and attenuate the detrimental effects of retinal ischemia. However, success in the lab has not been translated as clinical success yet. So practically, there is no clinically proven treatment for retinal ischemia. The only treatment is prevention, meaning that in our case, the only way to avoid retinal ischemia is by taking all the precautionary measures that exist during the administration of local anesthesia.
Why did you perform an optical coherence tomography, since no treatment could be conducted?
We had to find out why the child could not see and understand if any improvement was going to be expected, maybe at a later stage. Since these particles were found, it was obvious that the blindness was not transient and that no improvement would be expected.
Do you believe that Dr. Orphanidis might have caused the child's blindness, but not by malpractice?
I'm not the most qualified to answer this question, but definitely administering the anesthetic solution into an artery or administering with high pressure, it increases the chances of having an ocular complication like the one we saw in George's case.
Do you believe that if the child scrubbed his eye, this could be a factor that could justify George's loss of vision?
Maybe this would cause some ocular complications, but it would not justify the presence of the particles in his retina.
Thank you. Could the expert witness for Dr. Orphanidis take the floor and tell us how to address them?
I am Eleni Lambrou, a pediatric dentist, and I know Dr. Orphanidis from our postgraduate studies. Please address me as Dr. Lambrou. Dr. Orphanidis was an excellent student who always provided the best possible treatment for his patients. He was always very cautious and had a profound knowledge of the pediatric procedures he was asked to perform. Until now, he has had thousands of administrations of local anesthesia without ever facing any complications. I have collaborated with him in several patients' treatment under general anesthesia and never saw anything that could be considered malpractice. When I'm on vacation and an emergency happens to any of my patients, I will refer the patient to Dr. Fanidis, since he is the pediatric dentist I fully trust. If you see him working with kids, you will understand why he's the person that you can trust, but also that it is impossible to blame him for malpractice.
You do not consider the use of a 30-gauge needle and aspirating only once as malpractice?
No, I do not. During our postgraduate studies, we were taught to use a small 13-gauge needle for the local anesthesia for the upper quadrants in order to minimize patient discomfort. For aspiration, we were taught to aspirate only once and not twice, and we had no prior knowledge that 13-gauge needles can lead to false aspiration.
Were you taught to administer the anesthetic solution at a slow pace to avoid high pressure?
Yes, but in order to minimize patient discomfort, which is not an issue during general anesthesia. And no one has ever informed us to avoid quick administration to prevent any ocular complications. So for all of us who graduated from the same university, what is known is that injecting at a low pace will minimize the discomfort of the patient and will make the dental injection a painless procedure, and not that applying more pressure quickly can cause an ocular complication.
Do you believe that Dr. Fanidis should have informed the parents regarding the ocular complications that might happen after the administration of local anesthesia?
Practically no one during our studies has ever taught us that local anesthesia can result in ocular complications. So how could he do so, since he did not have that knowledge? Can you inform someone about something that you do not know? I would like to add that since this incident happened, I searched and found that in many dental schools, like ours, students are not informed about possible ocular complications that might be the result of local anesthesia.
Do you ever perform dental injections rapidly?
To be honest, yes. If I have uncooperative children whose parents wish to do the dental treatment at the dental office, we need to hold them during the ejection procedure to avoid injuries. The head needs to be stable and not move uncontrolled while a needle is inside their mouth. In these cases, I need to do it as quickly as possible. If the injection is done slowly, it is almost impossible to control the head of the child and the risk of injury increases.
Do you believe that you have ever injected anesthetic solution into an artery?
I cannot be certain, since I use 13-gauge needles, which, from what I have learned through this incident, often give false negative aspiration. But even if I knew it, I will not change it during my daily practice, since a different needle could turn a lot of my patients from cooperative to uncooperative, because of the discomfort they might experience.
During general anesthesia, would you use a different needle for the local anesthesia than the one you used in your daily practice?
From what I have learned after the incident, yes.
Thank you very much, Dr. Lambru, for your contribution. Let us now proceed with the final witness, Dr. Lena Dimitriadou. Could the final witness please present their side and how to address them?
Hello, everyone. I'm Lena Dimitriadou, and I am a dental surgery who teaches anesthesia at European University of Cyprus for the last 4 years. Please address me as Dr. Dimitriadou. In our university, all students know how to perform safe local anesthesia, and all the instructors make certain that during their clinical training, they aspirate twice before injecting the anesthetic solution. During the administration of local anesthesia, the dentist should take precautionary measures to avoid injecting local anesthetic into a blood vessel. In order to succeed, 25-gauge needles should be used, as those needles do not give false aspirations. And of course, the aspiration should always take place twice, at each site of entry. Regarding diffusion, lidocaine is preferred since it's more difficult to diffuse than articaine. Dr. Orfanidis might have used lidocaine, but he did not use the correct needle. He did not aspirate twice, and he only did one aspiration after already having injected a small amount of anesthetic solution. Also, he administered the solution rapidly, meaning with a lot of pressure. For all these reasons, in my opinion, he is responsible for malpractice and for the reversible blindness of George.
If you use the 25-gauge needle and perform aspiration, does it always give a positive aspiration if the needle has entered a blood vessel?
Yes, it does, as long as 2 aspirations are always conducted, which are the precautionary measures that each dentist should always follow during local anesthesia.
If the child would move during the injection, could the point of entry change? And even if the aspirations were negative, practically at the end, the needle might have been inserted into a blood vessel without even knowing it happened.
This is a probability, but under general anesthesia, the child usually does not move.
Do you think that the particles have been noticed in the choroid of the right eye could have the dental injection as origin?
Yes, I do, since the anesthetic solution contains particles in the form of preservatives, and Dr. Orfanidis injected it without following the proper steps to avoid the vascular circulation. Also, Dr. Solomou is certain that the particles are derived from the anesthetic solution.
Do you think that he maybe was not taught about the ocular complications that could occur during the injection procedure?
Maybe he was not taught about the ocular complication. However, all dental schools teach about the location of the veins and arteries, the central and peripheral nerves of the body, and the skeletal system of the entire body, with emphasis on the head and neck as part of the anatomy course. And no dentist should perform dental anesthesia without having a profound knowledge of the anatomy of the area they intend to inject. And of course, before performing a procedure, one should always be certain of what they are doing. Otherwise, they should not do it.
If there were any anatomical abnormalities, is there a possibility that Dr. Orfanidis administered safely the anesthetic solution, but still the particles reach the choroid area of the right eye?
Depends on the abnormality, what type and where it is located.
Could Dr. Orfanidis or you have known about any possible abnormalities?
No, it is impossible without doing further examinations, which will cause great discomfort to the child, as we are talking about anatomic variations. Of course, anatomic variations cannot be excluded, but if Dr. Orfanidis had taken all the precautionary measures and the child ended up with permanent vision loss, then we could say that the reason will be anatomic variations.
Is there a possibility that the particles reach the choroid retina by diffusion if the severity of the infection at the periapical lesion had caused bone resorption at the area and not through the articular circulation?
It might be another possibility, but this does not mean that the administration of the local anesthesia was conducted properly. If the bone was resorbed and the pressure was too high, maybe the particles could have reached the choroid of the retina by diffusion, but Dr. Solomou is more appropriate to answer this question.
Thank you all for presenting your perspectives. We will now proceed to the negotiation phase, during which the parties and their attorneys will have the opportunity to present their primary arguments and propose their preferred solutions. The ground rules established at the beginning of the mediation procedure remained in effect during this phase. In keeping with the principle of equality between the parties, one of the main principles of mediation, we will begin with Dr. Orfanidis' attorney, Ms. Kaleri.
Thank you, Harula. Our primary argument is that Dr. Orfanidis adhered to the established standards of care. While, of course, we empathize with George's situation, we believe that the subsequent complications are not directly linked to the dental procedure he underwent. We are open to working toward a resolution on the condition that my client, Dr. Orfanidis, does not admit fault.
Harula, thank you. Our concern revolves around Dr. Orfanidis' dental procedure, which, as we supported by the evidence, led to George's vision loss. We are pursuing compensation for George's suffering and his ongoing medical needs. Additionally, we are willing to collaborate with the other party to reach a resolution, provided that these concerns are addressed.
Thank you both for clarifying your positions and for being open in reaching a mutual agreement. From your statements, it seems that Dr. Orfanidis is not opposed to providing compensation for George's family. Is that correct, Dr. Orfanidis?
As my attorney here has affirmed, I adhered and operated within the standard of care. I am willing to provide compensation, albeit not unreasonably high, in order to assist George without this being construed as admission of fault.
Thank you, Dr. Orfanidis. Ms. Ageli, what is your stance? Would you accept the compensation without requiring Dr. Orfanidis to admit fault?
My foremost concern is my child's well-being, and I want to ensure that his medical needs are going to be taken care of. I am open to accepting compensation on this basis.
On average, the court awards around 100,000 euros in compensation. In your opinion, what amount would be most appropriate to award as compensation, Ms. Kaleri?
We consider 100,000 euros to be an excessive amount, and as such, we are prepared to offer 20,000 euros.
We disagree. We feel that 20,000 euros is insufficient to cover the extent of the damage, particularly given the upcoming medical expenses. Therefore, we are requesting a compensation of 50,000 euros.
Dr. Orfanidis and Ms. Kaleri, considering Mrs. Angeli's request for a higher amount, are you open in offering more than 20,000 euros in compensation?
We are prepared to offer a compensation up to 35,000 euros, but not exceeding that amount.
Does your client, Ms. Kalaitzaki, accept this amount?
We agree to this amount.
Would both parties be in agreement if the compensation were set at 35,000 euros under the condition that Dr. Orfanidis does not admit fault?
I agree, yes.
I also agree with that.
Congratulations to all parties for engaging in a productive dialogue today. It is encouraging to see a readiness to find common ground. We have arrived at a stage where an agreement is ready for consideration, so let's proceed with the signing of the agreement.
Thank you all.
We hope you learned something from this presentation today.
And this concludes our second case. We hope you enjoyed it. And I really want to congratulate this panel of our students. You were excellent. And also congratulate Dr. Taufik, who was the supervisor of this case, who was unable to attend today. And we hope that this is the beginning of more cases to come, and have this strong collaboration among these two schools. And thank you very much.